Peace, everyone. It's yours truly, Miriam Muhammad, aka Dana Riddick, coming to you guys to inform you on April 2nd, we had a successful rally. Upon the completion of our rally, we went into City Hall and passed out these booklets to all the councilmen and women, informing them of my husband, Eric Riddick's case. The title of the pamphlet is In Pursuit of Justice. Inside this booklet breaks down from A to Z the whole story behind Eric Riddick being incarcerated. It has alibi statements, affidavits. It has support letters. It has the brief history of the case. It has the expert firearms report, William Conrad. Just all the supporting evidence to show the actual innocence of Eric Riddick. So, upon delivering the booklets, one of the councilmen that reached out to us was David O. David O had a sit-down meeting with my mother-in-law, Christine Riddick, which turned into her being aired on her show, which was aired yesterday, April 17th, 2018. And, well, upon that note, I'm going to just play the interview so you guys can hear it.
Intelligent Talk Radio with Philadelphia Councilman David O.
We are back. Thank you for tuning in. You know, we were talking in our first segment with Penny McDonald and pastors Larry Anderson and Darrell Dade of Community Forgiveness and Restoration. And then we were talking to Bishop Peter Kwong, a name that is familiar to so many of our clergy leaders in the African American community, for his ministry of racial reconciliation, particularly between Korean Americans and the African American community. But now we're going to talk to Christine Riddick. She is a mother. Let me start with that. She's also been judge of elections here in Philadelphia for the past 20 years, and she's a advisory council member at the Francis Myers Recreation Center, and a member of the 12th Police District Advisory Board. Her late husband was a Philadelphia police officer. But the reason she is joining us today is talking about proof of innocence. Her son Eric is incarcerated right now. He spent 26 years in prison. But let me read you this. This is from an opinion, a concurring statement by a Superior Court judge, and this is what it says. No system of criminal justice is perfect. However, a system of criminal justice that prevents the correction of obvious errors is easily improved if only the legislature could see fit to do it. He is talking about the Post-Conviction Relief Act, and that is an act when evidence is not provided to the court through what I would say negligence of the attorney. But the Post-Conviction Relief Act here in Pennsylvania is a very tough act, and in some cases, and certainly if it is my case or your case, a matter of grave importance to us. And so, what this judge writes is this. I write separately only to express my utmost displeasure with the Post-Conviction Relief Act's failure to facilitate justice in this case, where it is clear to all that it is likely that an innocent man sits behind bars for no better reason than a poorly conceived statute. What does that mean? Well, what the judge is saying is this is the right decision to deny the appeal under this law, but this law is poorly written, and therefore, under this law, a person who is likely innocent remains behind bars. Who we're talking about is Eric Riddick, the son of Christine Riddick. Thank you for joining us today.
Thank you, Councilman O, and good afternoon to the radio listeners. I really appreciate Councilman O giving me this opportunity to continue to bring awareness to not just my son's case, but to all those behind the walls who feel they have no voice, that there's no one outside the walls that is trying to make sure, those who are wrongfully convicted, that their information is put out there to those who can correct the injustice, but also for those who are looking for redemption and second chances.
Yeah, let me tell everybody, this is how I met Christine Riddick. She came to my office. She was going to different council offices in City Hall, and she's been to different legislative elected officials. Apparently, I did not know that. I wasn't there when she stopped by. I caught her on my way in. I was somewhere else, and so we didn't get a chance to talk, but we set a time to meet. But what she did is she left a booklet behind. It is a booklet of evidence that her son and her daughter-in-law and that she put together. And so basically she set an appointment, said, please read this before we meet. And so the book sat on my desk for a while, and then before meeting I picked it up, and the first thing I did was read a concurring opinion, and it is the opinion that I just read. Wow, Justice Fitzgerald joins in this concurring statement. I mean, the thing about it is that I have never seen a judge of a court in an appeal write and say that likely an innocent man is behind bars because of a failure of a statute. Now, that is a pretty strong statement.
Yes.
And so I turned the page and I began to read about the case, and a couple things jump out at me. And I'm a former prosecutor. I've done a criminal defense as well. And so this is one of those very rare cases where not only does someone say, I'm innocent, but hands you the proof of it, the evidence of it. And so let me start with this. There was a person who was unfortunately murdered and shot, and then a eyewitness says Eric Riddick did it. He was on a balcony and he fired a weapon downwards and shot this man. The scientific evidence, the forensic evidence is that the bullets were fired horizontally or from a position upward, down to up, not up to down, right? Down to up,
and not downward,
upward and straight. So what happened? There were two different types of bullets, a 32 and a 22. And so it would indicate from the angles and everything else that two separate weapons were fired straight and from a downward to upward position, and that would contradict scientifically that someone standing above the victim would have fired downward. Next, the defendant, Eric Riddick, had alibi witnesses, three of them who were in court yet never called to testify. And it appears, although I can't say for sure, but it appears that the reason they weren't called is because the defense attorney never provided notice of alibi witness. And for those who don't know this, you just can't bring up an alibi witness who says, I was with this person, he weren't there, unless you provide notice to the prosecution. And so three alibi witnesses were in court throughout the trial, ready to testify, never called. And then the eyewitness recanted and said, I did not tell the truth.
Right. Actually, he provided affidavits.
Affidavits, yes. And so all this is brought into court on a post-conviction relief appeal.
Right.
And under the law, this does not get him a new trial, a new opportunity, or does not get him out of jail.
Right. And the unfortunate thing is that the court's reasoning was because of a technical error. The technical error being a particular paper was not filed in time, which is not true because my son's case continued based on what they say wasn't filed in time. So a technicality, my conclusion is a technicality is worth, is worth more than a human life, because a technicality can be changed. Just like a statute was written, it can be modified. It can be changed if it's shown to be cumbersome and burdensome to the very people that it's supposed to protect.
Yeah, let me say that many years ago, when I just got out of the military, after having served in the district attorney's office, I was approached by some people from New York who brought a case to me about a father who was doing life imprisonment, convicted of murdering his daughter. And they said he's innocent. And I said, well, yeah, everybody says they're innocent. I don't know, But they presented me with some documents because I asked for it. And I said, listen, I will look at it. And they were not brief and well organized like the booklet you gave me. So I poured through it. And what struck me was that there was a fire that occurred in the cabin in the Poconos, and the person who was found guilty and had passed his appeals and lost his appeals and everything, and so basically he was the father of a young lady, and he said that there was an electrical fire in the ceiling, and that's what happened. And then what I found was that the prosecution brought witnesses who said that he mixed 76 gallons of home heating fuel with gasoline and poured it throughout the cabin and then lit it on fire from the front door. And there was evidence that there was an electrical fire. But at trial, instead of saying there was an electrical fire, the attorney said, yes, there was 76 gallons of fuel. It was an arson, but it was a daughter who was committing suicide. And so that is a ridiculous a thing for the jury.
Yes.
Did he do it, or did the daughter, frail young woman, do all this? She had no car. He had no car. And so that issue, he was found guilty. And so once the evidence was presented, once it was found by me that there was evidence, and I got even more evidence that it was an electrical fire. And listen, it's very simple, folks. Despite all the expert testimony, what it comes down to this: if a fire is set with fuel on a carpet and it burns from the ground up, the bottom of the table is burned more than the top. The bottom of the mattress is burned, not the top. But what happens when the top of the mattress is burned? What happens when the top of the mattress is burned but not the bottom? What happens when the top of the desk is burned but not the bottom? Well, the fire came from the top. And there's so much simple evidence that shows that it's an electrical fire. But despite all this, we went all the way up, and through the PCRA, the Post-Conviction Relief Act hearing, the standard is that the attorney, for any reason, really, that he chooses, can decide to call witnesses, not call witnesses, present evidence, or not. And so what is new evidence? It's not what's new evidence that you and I think of it. It's evidence that was not available at the time. So if the evidence was available to the attorney, even though the attorney didn't present it or didn't find it, didn't look for it, it's not new evidence. That's a pretty harsh standard.
Yeah.
And so when and I'm happy to say that eventually through a federal court case, his appeal was successful and he was released from prison. But after many, many years. And in this case, this is the second time that I have seen evidence that shows that the person should not have been convicted in the first place, exactly. And yet this evidence is not making a difference.
Right. And that's the harsh reality. I mean, that happens, unfortunately, when my conclusion, when egos and appearance become more important than a human life, that is like perceived, like it's not important. for them, for those who are charged with protecting us, will not take the time, regardless on what side you are, whether you're the prosecutor or the defense attorney. If it's wrong, it's wrong. My understanding, the lawyer's oath that they take is represent your client and not the system. That means your first duty is to your client.
Definitely prosecutor, not persecutor.
There you go.
Certainly,
Yes.
if someone is guilty, if someone's done wrong, the prosecution prosecutes. It's up to the jury, the judge, a decision is
That's
made.
right. Mm-hmm.
But in this case, after the fact, all this evidence comes up that refutes the idea that this person is guilty or should have been charged.
Exactly.
And it is not making a difference. So there's really two things that appears to me that needs to be done. One is we have to certainly bring this to the attention of the legislature to say, listen, how can we have a statute that when you have proof that a person is innocent, it can't make a difference? It should.
Mm-hmm.
And the second thing is that we should certainly look at a federal appeal and also commutation or a pardon and otherwise. But certainly there are many things that have to happen, and I know you are working hard on it. But again, Eric Riddick, with all this evidence, scientific and otherwise, that he is not the person, but he did not really truly get his day in court.
No due process. He really didn't receive due process. Councilman O, my hopes and what I was looking at, I know in the booklet, if you had a chance to look at it, the state representative, Joanna McClinton, wrote several letters on behalf of my son, that's included in this Supreme Court brief that my son submitted. And my hope was that from a bipartisan position, that I have my state representative, regardless, she's a Democrat, and Councilman O, who's a Republican, can bipartisanly echo,
Yes,
the same sentiment in terms of providing some type of forum that the Supreme Court and others in the judicial system.
Okay, well, you definitely have that because, listen, doesn't matter what party you belong to, nobody should want an innocent man in jail.
Exactly.
All right, well, thank you for joining us, and listen, everyone, thank you for joining me. Tune in next Tuesday, 2 to 3, for In the Know with David O.
You've been listening to In the Know with David.
All right, you guys. If anybody wants to send any friend requests, on Facebook it's Eric Man Riddick. His Instagram page is Free Eric Riddick 24. If you would like to send emails in regards to support letters or questions, concerns, you can email us at tpctsinc@gmail.com. We just need to bring awareness, I'm pretty sure Eric is not the only individual that's going through the same situation. We have over thousands of individuals who are innocent sitting behind bars. We tired of being numbers. We got a voice. They have to hear us. We can't be afraid to speak up and do what we need to do to get our loved ones home. And on that note, peace.